Good evening, everyone. Making sure we got sound here. Testing A, testing B, testing 1, 2, 3. All right, greetings. All right, tonight we're doing a special episode on constitutional law, recognizing rights and establishing government. And this is from American Jurisprudence. Alongside, we'll also have Black's Law Dictionary 9th edition for reference on any definitions of words we might be unfamiliar with or might have a specific application in the law. So let's proceed. Oops, wrong one. There we go. Okay. Now, if everyone can hear me and just let me know that there's people can see what we're doing here in the chat. If you could just give me any kind of signal, a 1, hit the like, or ask any questions you might have specific to this topic. Let's get started. So let's start with a summary of constitutional law. The scope. This article deals with the basic principles of the American constitutional system. The federal and state constitutions and their nature, characteristics, functions, adoption, amendment, construction, operation, and effect. Included herein is a discussion of doctrines applicable to the determination of the constitutionality of statutes, the sources, distribution, and separation of government powers and functions, and, very important, fundamental constitutional rights and guarantees. So, starting with the federal aspects. The general aspects of constitutional law are such as, let's get back here. The general aspects of constitutional law, such as adoption and amendment of constitutions, the rules of construction, and the determination of the constitutionality of statutes. Those are our general aspects. So we get 3 of them here. The adoption and amendment, which are basically the creation and changing and addition of constitutions. The rules of construction, so the structure basically of our Constitution, because the Constitution is a written document, so it must be constructed under rules, and the determination of the constitutionality of statutes. So, a determination in law being a final decision, so let's continue. Which have application to the United States Constitution, as well as other constitutions, are discussed in this article. Also included in this article are treatment of specific aspects of federal constitutional law, such as the distribution of powers between state and federal governments, and the separation of powers within the federal government, as well as the nature and scope of specific federal constitutional rights and guarantees. Here we are again with we have fundamental constitutional rights and guarantees here, and specific federal constitutional rights and guarantees. So these are specific ones that are federal of these fundamental constitutional rights and guarantees. Okay, so this is going to be discussing the federal scope of these constitutional rights and guarantees, such as those involving equal protection of the laws. All right, now this is quite important. Due process of law. I want us to just pause for a second to think about this, is that this due process of the law, this little phrase right here, is what probably separates us from the rest of the constitutions of the civilized world. due process of the law is the only reason the rule of law has any functional purpose. The privileges and immunities of citizenship. Interesting. The privileges and immunities of citizenship. Obligation of contracts. Ex post facto laws. And bills of attainder. So let's start with this. Latin wasn't my first language. Probably not most of our audience. So let's figure out what the ex post facto laws are. Just a moment here. Oh, shoot, I got to do this one time. The first time, pull up this Black's Law here real quick. Oh, goodness. All right, Black's Law, where'd it go? 9th edition. Okay, here we go. Anyone out there still? Just want to see if there's anyone that's still out here watching. We still have anyone in the audience? Let me know. Oh, okay. All right. So let's see here. We're looking at ex post facto. A moment here. As I say, it's so much easier with a paper book sometimes. Suppose here we go. 689. Oh, we have Black's Law up here. Hang on a second. Shoot. Okay, so ex post facto, done or made after the fact, having retroactive force or effect. Interesting. Retroactive force, that's what this means in hindsight. So ex post facto, wait, here's another one here. After the fact, retroactively. Let's continue here because we have ex post facto law, ex post facto clause. So it behooves us to figure these all out while we're here. This is from 1848, where these others are from the 17th century and 18th century. So after the fact, having it, all right, so this is from the same period as the clause. And this one here is Latin from a thing done afterward, after the fact, retroactively. Do we still have anyone in the chat? Just checking to see here. And just want to see if this is working here. Yes. Okay, it looks like that's working. And is it working on the YouTube side? Tremendous. Okay, guys. So, let's see if that worked there. Yes. Okay, so let's continue here. So we have ex post facto clause. That's one of two clauses in the U.S. Constitution. Aha. So this is what we're checking out here. And just to be sure, ex post facto laws is what we're looking at here. We're about to get to that. Forbidding the enactment of ex post facto laws. There we go. Here's our ex post facto laws, 18th century. A law that impermissibly applies retroactively in a way that negatively affects a person's rights. as by criminalizing an action that was legal when it was committed. Interesting. So it's an impermissively application. Impermissive applies retroactively, especially in a way that negatively affects a person's rights, as by criminalizing an action that was legal when it was committed. Ex post facto criminal laws are prohibited by the U.S. Constitution. There we go. I hope anyone's here besides just me, because this is some powerful stuff we're learning. We're just getting started. But retrospective civil laws may be allowed. You get this? Ex post facto criminal laws are prohibited by the U.S. Constitution, but retrospective civil laws may be allowed. Interesting. See constitutional law, and that's what we're looking at. So let's continue, as recommended even by Black's Law. Okay. Let's continue here. Oh, bills of attainder. We can't forget that. Ah. 216. Wait a second. Maybe it's under bills. All right, well, let's try this one anyways. All right, so we have bill of attainder. Here we go. Cool. Archaic in this definition, but let's read it anyways. A special legislative act that imposes a death sentence on a person without a trial. Yikes. Okay. But that's archaic. So we have a special legislative act prescribing punishment without a trial for a specific person or group. Jeez. Bills of attainder are prohibited by the U.S. Constitution. Article 1, Section 9, Clause 3, Article 1, Section 10, Clause 1. Also termed Act of Attainder. All right, bills of pains and penalties. Constitutional law. So let's continue as recommended by Black's Law. Okay, so treated elsewhere are these things: the abortion, birth control, administrative investigations. I want people to pay attention to this. Admiralty, jurisdiction, constitutional basis of. There's a whole nother AmJur just for that. So that stuff does not apply to anything we're going over on this specifically. This is treated elsewhere. Same with aliens and constitutional rights, agricultural classifications, advertising, constitutional limitations on regulation. So there's a lot of these. So these are the different AmJurs that would have this. There's administrative law, which we went over a portion of previously. Admiralty, advertising, agriculture, aliens and citizens, elections, alternative dispute resolution for arbitration, constitutionality of statutes providing for arbitration. That's all alternative dispute resolutions. Same with arrest, federal constitutional aspects of. That's under arrest. Assistance of counsel at criminal trial under criminal law. So we have different ones for bankruptcy, vagrancy related issues, blasphemy and profanity, census, criminal law, evidence. These are all great AmJur volumes at any time. If we get recommendations, we can go into these even with more detail. So if anyone's personal interest in any of these topics, please let me know, and we'll see if we could open another little presentation on that aspect of American jurisprudence. As you can see, there's no shortage of topics that could be interesting to everybody. Let's continue here. We have contempt, abortion, birth control, copyright and literary property, counterfeiting, criminal law, libel and slander, couple of these here: defamation actions, constitutional limitations on the constitutional validity of statutes imposing criminal liability for these defamation actions, right? So all this is covered in other volumes of American jurisprudence. Double jeopardy, that's under criminal law, public officers, employees, criminal law, some more. We also have, I love the District of Columbia, constitutional basis for establishment of. We have a whole American jurisprudence dedicated to that. Congressional authority over the District of Columbia. Important stuff in this. Equal protection. So all of this is addressed outside of our constitutional law summary. So just keep that in mind, how much has been packaged on top of our Constitution. But what we're going to learn here is that all of this really doesn't matter until we've addressed what we're going to go over tonight. So let's get right down to what the topic is for this summary. Okay, so let's get to the definition and nature of Constitution and constitutional law. What is constitutional law? If someone asks you, what is constitutional law? We're going to find out. The word constitution means a declaration of fundamental laws or principles for the government of a nation or state. A constitution is the fundamental law by which all people of a state are governed. You get that? A constitution is the fundamental law by which all people of the state are governed. Pretty interesting there, the all people is the basic charter of state governance. A state constitution receives its force from the express will of the people. And is the embodiment of the will of the people regarding the limits on governmental power. Let's read this again here, because it's a long, long sentence, but it means a lot here. A state constitution receives its force from the express will of the people and is the embodiment of the will of the people. Well, let's look at this word here, embodiment, because let's see if there's a legal I'm checking here in Black's Law. Hit the like there if there's anyone that's out there or in the chat, just so I know this chat's working here. If there's any questions or anything we want to elaborate on, by all means, let me know. Well, let's get to this Black's over here. And we're looking up embodiment. And I'm trying to find, there we go. 627. Okay. There it is. Embodiment. Well, in patents, wow, the tangible manifestation of an invention. Interesting. The embodiment is the tangible manifestation. And of course, this will be in patents in the cases there. The method for using this tangible form. That's an embodiment, is a method for using that form. The part of a patent application or patent that describes a concrete manifestation of the invention, meaning something in real life that you can hold, see, touch, whatever. Concrete, not abstract, as in leaving things out, but complete. Embodiments are less common in software, or process patents than in manufactured-related patents. So that's strange. So this is an embodiment is in the context of patents. Let's see if doesn't look like there's any other embodiment. No, this is like a patent law term in this case. I'm not sure if it applies here in constitutional law. Let's get back and see. No. So this is just a dictionary term of embodiment. So let's get back to this. So it's a basic charter of state government, the Constitution, fundamental law, which all people are governed. The state constitution receives its force from the express will of the people. It is the embodiment of the will of the people. So I guess, it's a concrete expression of that, is what that means, regarding the limits on governmental power. The basic charter, so it receives its force from the express will of the people. It is the embodiment of the will of the people regarding the limits on governmental power. Wow. The legitimacy of any constitution is derived primarily from the consent of those agreeing to be bound by it. The legitimacy of any constitution is derived primarily from the consent of those agreeing to be bound by it. Where a constitution asserts a certain right or lays down a certain principle of law or procedure, it speaks for the entire people as their supreme law. Whatever the Constitution prescribes, the General Assembly and every officer or citizen to whom the mandate is addressed must do, and whatever it prohibits, the General Assembly and every officer and citizen must refrain from doing. Now, remember, this comes from the will of the people. Now we're saying officer and citizen and General Assembly. Keep this in mind. The government has broad powers. Before I continue, I just want to keep in mind that there's no mistake or arbitrary or capricious decision of using the words people, person, citizen. They're used very intently here. This language is all sharp and to the point, and it behooves us to pay attention to these slight differences that might seem slight but are very significant. Okay, let's continue. Whatever the Constitution prescribes, the General Assembly and every officer or citizen to whom the mandate is addressed must do. And whatever it prohibits, the General Assembly and every officer and citizen must refrain from doing. So anything that it prohibits, they must refrain from doing. The government has broad powers, but the means it uses to achieve its ends must be consistent with the letter and spirit of the Constitution. Beautiful statement. A strong public desire to improve the public condition is not enough to warrant achieving the desire by a shorter cut than the constitutional way. Wow, that sounds pretty cutting edge. A strong public desire to improve the public condition. Even a strong public desire is not enough to warrant achieving the desire, strong public desire to improve a public condition. That strong public desire is not enough to warrant achieving that desire by anything shorter than the constitutional way. Sorry, but that's the way it's going to be. The powers granted under the Constitution are not infinite. The power of the Constitution grants, it also restrains. Although a constitution may be either written, as in the case of the United States, or unwritten, as in the case of Britain, the word constitution, as applied to the organization of our federal and state governments, always implies a written document which is understood to have been acted by the direct action of the people. You get this? Although a constitution may be written or unwritten, as in the case of Great Britain, the word constitution, as applied to the organization of our federal and state governments, always implies a written document which is understood to have been enacted by the direct action of the people. A constitution is a fundamental document which, in recognizing citizens' rights and establishing government, provides essential checks and balances whose complexity is to be neither undervalued nor disregarded. Constitution is a fundamental document which, in recognizing citizens' rights and establishing government, provides essential checks and balances whose complexity of establishing our checks and balances of government is to be neither undervalued nor disregarded. Constitutional law, which deals with the interpretation and construction of constitutions and the application of this fundamental law to statutes and other public acts because of the American governmental system, occupies an extremely important position in the jurisprudence of this country. Constitutional provisions gather meaning from the experience of the people. Are you listening to this? Constitutional provisions, things the Constitution provides us, gather meaning from the experience of the people. And the courts should expect that modern society will mold and shape constitutional principles into new and useful forms. Lots of footnotes here. Of course, we get the Mayberry versus Madison, etc., here. Lots of stuff for research here. Determination, yes. This is a well-established law we just went over here. Is there anyone out there? Distinction between constitutions and statutes. So as we're getting into constitutional law, it's important for us to make these distinctions here. Okay, and let me see here. Nice. Hello, Los Angeles, Spike. Okay. A constitution differs from the statute in that a statute ordinarily provides some details of the subject in which it treats. In contrast, a state constitution sets broad general principles, and its very purpose is to endure for a long time and to meet conditions neither contemplated nor foreseeable at the time of its adoption. This is an interesting concept right here. Because when you think about this, for a constitution, it differs from a statute because a statute provides some details of the subject it treats, so something very specific. In contrast, a state constitution sets broad, general principles, and its very purpose is to endure for a long time and to meet conditions that are neither contemplated nor even foreseeable at the time of its adoption. The Constitution is the framework of the government. Containing general principles upon which the government must function. So the Constitution is a structure, it's the framework that the government, containing the general principles, right, upon which the government must function. So a state constitution receives its force from the express will of the people. Statutes, by contrast, are enactments and rules for the government of civil conduct, promulgated by the legislative authority of a state. Okay, you know where we're going with this. I don't know what this word means, but it's one of those words that's harder to say than even remember. Let's see, here we go. Give us a moment here. We're doing this. Let me just find this here. I tell you, I love having a textbook in front of me instead of this. I don't think we're going to find it in black, so let's give it a shot anyways. And oops, let me get back to this. What do we spell this word? Promulgated. Yeah, okay. Let's go against the R's. I don't think it's in here, but it might be. Sometimes the search doesn't work so well. Oh gosh, a lot of Latin stuff in this. Wow. All right, we're getting close. I take it's on the screen, right? Good. If anyone's old enough to remember the microfiche, this is the only way. So you can go faster too. You have the fast one, but there we go. All right, we're close. Wow. Very close. Yeah, it's hard to find out well at the top. Here we go. Promote. Yeah. I don't think we have it in here. Where'd it go? Where's the M's? Promulgate? It is here. What do you know? I don't know why it didn't show up. Sometimes these things don't search because of the characters. It's the official publication of a new law or regulation by which it is put into effect. So it's the official publication, the promulgation. Jeez. Promulgation or promulgation. Promulgation sounds good to me. Promulgation. So it's the official publication of a new law or regulation and this is by which it is put into effect. So we get that down. Okay, let's get back. The state constitution receives its force from the express will of the people. Statutes, by contrast, are enactments and rules for the government of civil conduct, promulgated by the legislative authority of a state. So they're written laws that are issued by the authority of a state, legislator. Instead of general principles, a statute provides details of the subject of the statute. So details of the subject, as opposed to the Constitution being a framework of the government, the general principles on which the government must function. So we say it's a structural form for the function of it, and the details are going to be provided by the statute. Because the state constitution is the express will of the people, and its very purpose is to endure for a long time and to meet conditions neither contemplated nor foreseeable. So to say that this is something that they couldn't have foreseen when the Constitution was written would not be a valid argument, because by its very nature, a Constitution is written for things that cannot be foreseen nor contemplated at the time of the writing. It's meant to endure for a long time, and it's based on a broad set of principles, right? Let's continue. As an expression of the will of the people, a state constitution stands above legislative or judge-made law. Thus, because constitutions constitute the supreme law, they preempt contrary statutes or rules. Accordingly, the people's constitutional standards must always prevail over the legislator's statutory standards. Interesting, huh? Accordingly, the people's constitutional standards must always prevail over the legislator's statutory standards. So constitutional standards must always prevail over legislators' statutory standards, should the latter be lower. So if the standards are lower for the legislator, then you have to go for the constitutional. If the standards for the statutes made by the legislator have a higher standard, they may apply. But where a constitution speaks plainly on a particular matter, it must be given force and effect as the paramount law. Okay, when it speaks plainly on a matter, in other words, when there's no real difference between or any kind of standards that would differ between statutes and the Constitution, when it speaks plainly on a matter, it must be given full force and effect as the paramount law. And where statute or other rule and a constitutional provision are in conflict, look, where statute or other rule and a constitutional provision, something provided by our Constitution, are in conflict, the constitutional provision must prevail. All right, let's get to the good part here, the observations, which I love in American jurisprudence. Because even if you didn't understand everything, we just went into detail there. Hang on a second. There we go. Even if you don't understand everything I just said there in detail, the observations here should help make it so that you can what's going on here? That you can see, you'll be able to understand what they just said. So on our observation here, it says, there is authority that a constitution is but a higher form of statutory law, so that, for example, the state constitution is looked to where a court is searching for a statutory law on a subject, and there is no relevant statute per se. In the event, both constitutional and statutory principles should be liberally construed to further the goal of allowing the people to express their will. Wait, let's read this again. So there's authority that a constitution, there is an authority that a constitution is nothing really but a higher form of statutory law. So that's another way to perceive this, is that it's not just a structural framework, but actually a higher form of statutory law. So there is authority that might support that argument, that perspective. So that, for example, the state constitution is looked to where a court is searching for a statutory law on the subject. And there's no relevant statute per se. So if they can't find a relevant statute, they'll look to the state constitution. But in any event, both constitutional and statutory principles should be liberally construed, meaning that you should construe them liberally, not really strictly to one or the other. It should always be, are you following this? In any event, that's in any event, both constitutional and statutory principles should be liberally construed, meaning not rigidly, liberally, to further the goal of allowing the people to express their will. To further the goal, not just protect or anything, to further the goal of allowing the people to express their will. Heavy stuff here. And I hope everyone pays attention to that, because that's really the essence of it right there. So you might want to argue on one side that it's just constitutional law is simply a higher form of statutory law, so that you just look to the if there's no state statute or if there's you would look to the Constitution, right, to see if it would apply to where there's a statutory subject matter, and if there is none, then you could use the statute. So it would be the higher form of just another law, statutory law, so to speak. And there's no relevant statute per se, then of course you would go to the state constitution in that case as a judge. But in any event, however you want to look at this, whether it's just another form of statutory law, meaning constitutional law, or if it's that we said there before, which I kind of more into the school of the structure part of it, of the principles. In any event, both the constitutional and statutory principles, whichever ones you're looking at here, they need to be construed liberally in one direction. They should be. I don't know why you wouldn't, but they should be construed liberally. And the reason is to further the goal of allowing the people to express their will, the will of the people. That's the goal of constitutional law, is to make sure they're expressing the will of the people in every step. You have to check back as to what is the functional goal, the purpose of a constitution. Let's get back to that before we continue, because I want to be very clear about this. By establishing this, fundamental laws of principles for the government, fundamental law by which all people of the state are governed, but the legitimacy is derived from the consent of those agreeing to be bound to it. The reason why is because it receives its force from the express will of the people. There's no force without the express will of the people. It comes from the consent of those agreeing to be bound by it. Rule of law. There has to be some protections here that its force has to come from the will of the people. Without the will of the people, a state constitution has no force. Let's continue. Any questions in the chat? All right, so we're making these distinctions here because this is what constitutional law is about here. If you want to argue constitutional points, you need to understand these distinctions between statutes and constitution standards first, so you know which apply and where. And it avoids a pitfall of having something misapplied or rejected because it wasn't structured right in the way you made pleadings. So it's always good to make sure that you have these distinctions very clear in your mind So again, the Constitution, the framework, is what we were saying here, and it's an expression of the will of the people. All right, let's get back to this. We passed by where we were? Yeah, we are. Sorry. So we got our distinctions down. We did our observations here, and now we're going to continue. So, characteristics of constitutions. What are the characteristics? You could say these are attributes and such. But yeah, the characteristics are important to know. So let's go over this. All right, the term constitution. Yeah, a second here. Make sure it's still working here. Looks like it is. Yep, cool. All right, the term constitution implies an instrument of a permanent and abiding nature. However, a constitution is intended not merely to meet current conditions. Interesting. Like we said, this is something that's supposed to be looking at unforeseeable and things that are not contemplated at the time of its construction. Okay, a constitution is intended to endure for ages to come, and it must adapt itself to a future that can only be seen dimly, if at all. A constitution is an instrument of progress intended to stand for a great length of time. The United States Constitution is said to be a law for the rulers and the people, equally in war and in peace, and to cover with its shield of protection all classes of persons at all times and under all circumstances. Footnote 6, we got to look at this. What is that referring to? Kennedy versus Mendoza-Martinez, 1963. Wow. Although the permanent nature of a written constitution may at times seem to stand in the way of progress, its stability is intended to protect the people from frequent and violent fluctuations of public opinion. Since state and federal constitutions are limitations on the power of the people as against the impulses of mere majorities. So let's unpack this one here a little bit. Although the permanent nature of a written constitution may at times seem to stand in the way of progress, its stability is intended to protect the people from frequent and violent fluctuations of public opinion. Its stability, the stability of our written constitution, is intended to protect the people from frequent and violent fluctuations of public opinion. Since the state and federal constitutions are limitations on the power of the people as against the impulses of mere majorities. See, the state and federal constitutions are limitations on the power of the people as against the impulses of mere majorities. In other words, what this is, let's continue here and I can elaborate on this if they don't do a better job, which I'm sure they will here. However, a constitution is not so rigid that it always mandates the same outcome, even when its principles operate on a new set of facts that were previously unknown. So that's an interesting adaptation feature. It's not so rigid. And remember before, it must be liberally applied so that it's always in the favor of the people. That it always, the will of the people, I should say. That it always mandates the same outcome. It's not that rigid. You could have different outcomes when the principles operate on a new set of facts that were previously unknown. So it is flexible enough to handle that, but it must be done within its structure, because it is recognized that the framers of the Constitution cannot anticipate conditions which may arise thereafter in the progress of the nation, or establish all the law which from time to time may be necessary to conform to the changing conditions of a community. Constitutions traditionally do not deal in details, but enunciate the general principles and the general directions which are intended to apply to all new facts which may come into being, and which may be brought within these general principles or directions. So any new facts that could be brought into these principles and directions, right? It was designed to be able to be applied no matter what they could be. So the characterization of these things, the changing conditions of a community, are all thought into the design of these constitutions, because they cannot anticipate all these things. So they have to establish ways that they can adapt. So again, because it is recognized that the framers cannot anticipate conditions which may arise thereafter in the progress of the nation, because remember, it's all about progress, or establish all the law from which time to time may be necessary to conform to the changing conditions of a community, meaning that statutory law, right, can't be done by the framers because statutory law is more specific to that community. Constitutions traditionally do not deal in details, but enunciate the general principles and the general directions which are intended to apply to all new facts. So you apply these principles and directions to the new facts. Are they still following these principles? And is it still going this general direction of progress, typically, which may come into being and which may be brought within these general principles or directions. As a general proposition, the United States Constitution does not tolerate pretext that covers up unconstitutional motives. That's important right here. As a general proposition, the United States Constitution does not tolerate pretext that covers up unconstitutional motives. That's footnote 13. Let's see what it says here. That's recent. Whole Women's Health Alliance versus Hill, and that's 7th Circuit 2019. So, again, does not tolerate pretext. So, a good thing to do is look up the word pretext in a legal context, because I believe it might have a specific meaning here. Yeah, let's look here. Give me a moment here. Here we go. Pretext. There it is. 16th century, a false or weak reason or motive advanced to hide the actual or strong reason or motive. Wow. So it's a weak reason or motive, and it was advanced to hide the actual or strong reason or motive. So you're giving it's a pretext. So I've heard the term false pretext. It seems to be double negative, right? Yep, that's it. Pretext and pretextual. Let's look at the rest of these things they have here. So we have pretextual arrest, pretext, okay, that's it. We're done with that. They don't give much on the derivatives here, but they do give some civil rights. That's where we could find it in the civil rights. But it is a weak reason, a false. Pretext in itself is a false reason or weak reason or motive. And it's advanced to really hide. So the pretext is something that's done to hide the actual or strong reason. I like that, strong reason. Okay. Let's get back. Cool. All right, that's working. Let's hit that like. Okay. Now let's continue. U.S. Constitution does not tolerate giving those weak arguments to cover up the strong reasons, right? It covers up unconstitutional motives as a general proposition. So this is important. When you see people doing unconstitutional motives and they're giving a weak reason to cover up the real strong reason, that could be a constitutional law violation, which, looking at this case here, seems like you're going to find all the information you would need because this made it into case law. There it is right there, Seventh Circuit. All right, let's continue. Now we're on to the functions or purposes of constitutions. All right, let's see how we're doing on the stream here. We're at an hour, and we're going to be summing up pretty soon, so let's just finish up here. The purpose of a constitution is to assign to the different departments their respective powers and duties, and to establish certain fixed principles on which the government is founded. The United States Constitution is a primer of fundamental principles for the conduct of a developing federal system rather than a manual of technical rules. Did you get that? So it's a primer of fundamental principles. And legally, let's see what they have for primer. I believe it should be a moment here and see what they got here. Yeah, no, we got to look. All right, 1339. Primer or primer. Primer first, primary. The United States is the first or the primary of fundamental principles for the conduct of a developing federal system rather than a manual of technical rules, right? It's our foundation of our fundamental principles. The purpose of the United States Constitution was to take government off the backs of the people. Furthermore, the idea of the United States Constitution was to withdraw certain subjects from the vicissitudes of political controversy. I don't know if this one's in here. I might have to pull up the regular one for that. I'll admit I don't know what that means. Vicissitude. Jeez. I think it's in here. How do we spell this again? See. Vicissitudes. VCISS. Nope, I don't think it's in here. They use it. Man, I bet it's in here. Just like the other one. It just didn't show me. Oh, gosh. Wow, that really is annoying, though. You can look up in a regular dictionary, too. But let's just see if I can find another one really quick here. Where'd it go? Vicissitudes of political controversy. The idea of the United States Constitution was to withdraw certain subjects from the vicissitudes of political controversy and to place them beyond the reach of the majorities and officials, and to establish them as legal principles to be applied by the courts. So let's get back to this here and see if I can find it. Oh, shoot. What happened here? Sorry about this. Get back to this. That's what we're looking up here, right? Yeah, it's strange. I see it being used, but I don't see it being defined. Which I find kind of odd. In the appendix, wow. Let's try something else here. And we'll do like we did before and just kind of get to it the hard way. Oh my gosh. Almost there, hang on. Oh gosh. V. Well, let's go here, this is close enough. Wow. All right, let's see if we can find it here. Make sure I get you guys on the same screen I'm looking at. Yep. Okay, this two. See, VIC I. Vicissitude. Vice, vicis. We're getting there. Nope. Yep. I don't see it. All right, SS. Nope. All right, so 10C looks like this could be the root of it, maybe. I guess this would be vicious. Let's see what we got here. I think we're at the root here. Vicinage. Vicinity, proximity. No, that can't be it. Little 10C. This looks like it here. No. Overlaying to a sheriff. No. Okay. So, dictionary definition for that, guys. Anyways, that's part of the burden of doing this right, is to make sure you're not leaving a word undone. And to place them beyond the reach of the majorities and officials, and to establish them as legal principles to be applied by the courts. Also, removing state trade barriers was a principal reason for the adoption of the United States Constitution. No one in chat wanted to give me that word, huh? I don't have the other dictionaries handy here. I don't want to take any more delay. And I don't have the paper one's not in the room either. Let me continue. The United States Constitution does not exist to guarantee efficiency. It exists to guarantee individual liberty. That's kind of funny because, all right, the United States Constitution does not exist to guarantee efficiency. It exists to guarantee individual liberty. So the Constitution would be there to keep courts from existing for efficiency rather than to guarantee individual liberty. You can't use collective efficiency because it doesn't exist to guarantee efficiency. It's there to guarantee individual liberty, the United States Constitution. Thus, one of the primary functions of a constitution is to protect the people against arbitrary actions by their own government or by the courts thereof. The most important purpose of a state constitution is to furnish the basis for the government it establishes That is, to prescribe the permanent framework of the system of government, the system, the interrelated processes of government. The purpose of a state's written constitution is to define and limit the powers of government and secure the rights of the people. That's the purpose of a state's written constitution. Define the powers of government and limit the powers of government and secure the rights of the people. It is customary for constitutions to prescribe and limit the powers of the government and thereby to operate as bulwarks of liberty for the protection of private rights. Public policy is the cornerstone and foundation of all constitutions. However, although public policy on a given subject may be determined by the Constitution itself, important here, as we saw before, no matter how much the public opinion or public policy wants something done with their desires, public policy considerations, or their desires, as we read previously, public policy considerations cannot override constitutional mandates. Powerful stuff. Lots of footnotes here. No notes on the footnotes, so we'll just pass by that. If you want, that's of course for further reading. Really good stuff here. And we get to the theoretical basis of constitutional law. I think we'll read this one, and this is where we're going to end, because this is very brief. And this is going to help sum up why we're here today and what we really want to leave this panel knowing. All right. I'm glad this thing's working here. Did you guys get that one there in the... All right, cool. Keep it up. Let's keep going. All right, this is where we're going to end it, and then we're going to go on to audit them. Make sure everyone subscribes to, where'd it go? Audit them. And we can put the link in the chat there too. Actually, he can when he comes back to the chat. Clear that off, and let's continue. Now we're going to get to the theoretical basis of American constitutional law generally. So after learning all we've learned from the history, the construction, the purposes, and such of constitutional law, the Constitution, I should say, and the distinction between that and statutory laws, we want to look at the theoretical basis now of our American constitutional law. The United States is a constitutional democracy. The constitutional form of government as it exists in the United States is based on the fundamental conception of a supreme law expressed in written form in the United States Constitution. So that's U.S. Constitution, Article 6, Clause 2. The United States is a constitutional democracy. This came out of this case, Smith versus Allwright. But what we have in the U.S. Constitution, Article 6, Clause 2 is a constitutional form of government. Constitutional form of government as it exists in the United States is based on the fundamental conception of a supreme law. So we have to conceive of a supreme law, and then it is expressed. It is expressed. Remember, a patent is not just an idea, it's an expression of an idea. We came across that word patent earlier, I believe. Or it was a word that was related to patent law. Embodiment. Expressed. The embodiment is the written form. That's the word. So as we see here, the expression in patent law, and the patent really is an expression of an idea, is patentable, not just an idea. And when you think of an embodiment as the concrete idea, in that a concrete form of the supreme law, it can be expressed concretely in a written form. So it's the embodiment of this fundamental law. It's a written form. So let's read this again. The constitutional form of government, as it exists in the United States, is based on the fundamental conception of a supreme law, expressed in written form in the United States Constitution. And that's supported by the Article 6 of the U.S. Constitution, Clause 2. Constitutional government by the people represents the greatest and grandest struggles of humanity for its betterment, and in its accomplishment marks the uttermost political accomplishment of the human race. And that was State versus Superior Court of King County, Washington, and that was 1910. That's some powerful language there. Constitutional government by the people represents the greatest and grandest struggles of humanity for its betterment, and in its accomplishment marks the uttermost political accomplishment of the human race. The limitations imposed by the American system of constitutional law on the actions of the governments, both state and national, are deemed to be essential to the preservation of public and private rights, notwithstanding the representative character of our political institutions. Interesting here, the representative character of our political institutions, and that's notwithstanding those. So, limitations imposed by our system of constitutional law on the actions of government are deemed to be essential to the preservation of public and private rights. In the United States, the right of sovereignty is vested in the people and is exercised through the joint action of the federal and state governments. That's footnote 6. And that's State versus Schumacher, Indiana, that was 1928. And then Bignell versus Cummings, Montana, 1923. State versus Kohler, Wisconsin, 1930. So those are pretty well-established laws, I would say. As to this date, they are still holding strong. Strong reasoning. All right. And, okay, that's a good place to leave off on, because I don't want to talk about redcoats at the end of this thing here. It's powerful words, really nice stuff here. I hope it was very inspirational for everybody. Let's see if this is working the way it's supposed to. There we go. All right. That should work too. Cool. And let me see if I can get this. Yeah, I want to thank everyone very much for coming over here and spending time to go through this with me. Again, this is something where not only am I'm learning about this stuff as we go along, but it's great for everyone else to do this too, because at some time in our life, it's very likely that this could come into play for you. And I've found times where it's actually been something where it's helped me out when I didn't really expect it to. And it's good to know this stuff just in the back of your head. There's times where I've been lucky to have just acted in ways I should have known had I read this, and just being cautious, I was fortunate enough to have abided by things I should have known through American jurisprudence. So that alone has behooved me to study further in other aspects that I haven't known, and to really, make it so that the way we get about seeing our system of jurisprudence here in this country, and the way we approach statutes, laws, the value of our Constitution, and what really makes it unique to all other countries of the world. This is really the national treasure we have is our Constitution. And constitutional law is a way that we're able to retain this thing and let it endure the test of time it was intended to, and a way to keep our fundamental principles in line regardless of changing conditions and public opinion, that these essential rights are built into our country, that the government relies on the consent of the people, the sovereignty lies within the people, and the government has to act in the will of the people in its duties. Anytime it tries to hide that through pretext or giving weak arguments to hide the intent, which could have been unconstitutional, is frowned upon in constitutional law. So as soon as that it could be uncovered in a case, it immediately sets it on a footing of failure for that party. Constitutional law is there to protect the people above everything. That must always be liberally interpreted when there is a conflict between constitutional law and statutory law, to always be liberally interpreted to be in the favor of the people's interest. So on that, I would like everyone to continue to please join me with this journey of learning American jurisprudence, which is the true strength of our nation. It's not taught very many places that I can see these days, so it's upon us to learn this. This is our own duty, really, to do, and it's the most important thing you can do as one of the American people, and the way to really show the appreciation of those that came before us and sacrificed a lot for us to have this system of American jurisprudence. Again, thank you all for coming, and please subscribe to be in touch for the next stream. And again, I appreciate everyone stopping by. Peace out.